Chairman of the Bar Council, Additional Solicitor General of India, Additional Advocates General, Deputy Solicitor General of India, Public Prosecutor, President of the Telangana High Court Advocates Association, Registrars, Director of the Judicial Academy, Secretary of the Telangana State Legal Services Authority, Secretary of Law and Legislative Affairs, Government of Telangana, respected senior members of the Bar, family members, relatives of Justice Abhinand Kumar Shavili, dear friends. We have assembled here today in this full court to bid farewell to Honourable Justice Abhinand Kumar Shavili today on 7th October 2025 on attaining the age of superannuation after more than 8 years of distinguished service on the bench of the Honourable High Court of the State of Telangana. Justice Abhinand Kumar Shavili was born on 8th October 1963 in Hyderabad to Dr. Subbarao Shavili and Srimati Sangam Yashoda Shavili. His Lordship's father and mother are natives of Hyderabad city, meaning His Lordship's is not only a native of Telangana, but also a son of the soil of Hyderabad city. His Lordship's father, Dr. Subbarao Shavili, was among the early medical graduates in Hyderabad, being the third batch of Usmania Medical College, Hyderabad. His Lordship's father began his career as a medical officer in the erstwhile Hyderabad state, serving across Marathwada in places such as Amba Jogai, Latur, Beed and Aurangabad, which were part of Hyderabad state. Upon the formation of the state of Andhra Pradesh, he opted to serve his native state and combined his distinguished medical service as District Medical and Health Officer Warangal and Mahbub Nagar, later being promoted as Zonal Officer for the Rayalaseema region. A dedicated physician, a man of simplicity, was known to travel to his duties on a bicycle till his last day before his demise on 30th January 1987, coincidentally, poignantly with Martyrs' Day. His Lordship's mother, Srimati Sangam Yashoda Shavili, was an accomplished woman who served as president of the Mahila Mandal. Deeply spiritual and culturally inclined, she recited slokas and personally performed homams on her children's birthdays. A gifted artist and a talented handicrafts maker, she was equally known for her compassion tending to her family's ailments with a treasure trove of traditional home remedies. She had a rare honor of receiving a Ratnam from the father of the nation Mahatma Gandhi during his visit to Hyderabad, a testament to her grace and social service. Lordships had his early education at St. John's Grammar School, Hyderabad, followed by Nrupatunga for his junior college, degree at Nizam College, and he did his LLB from the campus Law College, Usmania University. His Lordships enrolled as an advocate on 31st August 1989 in the Bar Council of Andhra Pradesh. In his distinguished practice, His Lordships handled service law, constitutional and allied branches with equal command. His Lordships was trained in the chambers of D. Linga Rao and later under Honourable Justice Nuti Ram Mohan Rao. Lordships also rendered valuable service as standing counsel for the High Court of Judicature of Hyderabad for both the states of Telangana and Andhra Pradesh. Lordships was elevated to the bench of the High Court of Judicature at Hyderabad for the states of Telangana and Andhra Pradesh on 21st September 2017 and later became a permanent judge of the High Court for the state of Telangana in July 2023. The Lordships also discharged the responsibilities of the office of Acting Chief Justice of this court. Justice Shavili also served as Chairman High Court Legal Services Committee for 2 tenures from 1/7/2022 to 3/1/2023 and 28/3/2024 to 36/2025. He also served as the President of the Telangana State Judicial Academy from 2/1/2023 to 31/3/2024 and again from 1/7/2025 till date. It is well acknowledged that in the domain of service law, His Lordships had been regarded as a master. His Lordship's judgments in matters relating to recruitment, seniority, service condition and disciplinary proceedings have provided much needed clarity and direction in areas that deeply affect the careers and livelihood of public servants. His Lordship's ability to strike a balance between constitutional principles and fairness to individuals has strengthened public confidence in the system of justice. During his tenure, His Lordships has disposed of nearly 30,000 cases, including a considerable number of long pending matters. This achievement is more than a statistic, it is evidence of a work ethic anchored in conviction to render justice. Many of His Lordship's judgments are widely reported. To name a few of his notable judgments, in the case of Venkateshwarlu versus High Court of the State of Telangana, reported in 2022 SEC Online 118, decided on 19 January 2022 by a bench of Chief Justice Satish Chandra Sharma, as His Lordship then was, and Justice Abhinand Kumar Shavili. The judgment was authored by Justice Abhinand Kumar Shavili. The writ petition was filed by the petitioner as Superintendent of Judicial Service, questioning the disciplinary proceedings that culminated in the imposition of punishment. While serving as a junior assistant in the mobile court at Khammam in 2006, the petitioner was directed to handle copy applications. During that process, he furnished original documents to the copying section, duly noting this in the docket sheet, but on returning the documents to the record, he failed to round off the entry. Treating this omission as misconduct, the district judge initiated disciplinary proceedings and upon inquiry imposed the penalty of reversion from superintendent to junior assistant by the orders dated 6/5/2014. The petitioner preferred an appeal where the appellate authority, by order dated 29/7/2016, modified the penalty, taking a lenient view from reversion to stoppage of 2 annual increments with cumulative effect. In the present writ petition, the petitioner contended that the inquiry had not been conducted in accordance with Rule 20 of the CCCA rules, that principles of natural justice were violated and that he was denied an adequate opportunity to defend himself. It was urged that the punishment, even as modified, was arbitrary and disproportionate. On behalf of the respondents, it was submitted that the petitioner had been given ample opportunity to defend himself, that the inquiry was conducted strictly in terms of the CCCA rules. Having considered the submissions, His Lordships observed that the appellate authority had already exercised leniency by converting the penalty of reversion into stoppage of 2 increments. Importantly, the petitioner had not demonstrated any specific violation of natural justice or prejudice caused by the conduct of the inquiry. In the absence of such defect, the court held that interference under 226 was unwarranted. Accordingly, the writ petition was dismissed. This decision reflects His Lordship's approach in disciplinary jurisprudence, recognizing the scope of judicial review in service matters, applying the prejudice test when principles of natural justice are invoked, and respecting the discretion exercised by appellate authorities, especially where leniency has already been extended. In the case of Satta Shekhar and others versus Telangana Public Service Commission, Hyderabad, reported in 2025 2 ALD 163 by a division bench decided on 18th October 2024, Justice Abhinand Kumar Shavili and Justice Lakshmi Narayan Alisetti. These writ appeals are filed by unsuccessful candidates who had participated in the preliminary examination for Group 1 posts notified by the Telangana Public Service Commission. The appellants contended that the Commission acted illegally in cancelling its earlier notification dated 26/4/2022 for 503 vacancies and issuing a fresh notification dated 19/2/2024 for 563 vacancies. They also raised grievances against the final answer key published on 7/7/2024, contending that certain questions, including question number 41, relating to environmental legislations had erroneous answers, supported by a Ministry of Environment and Forest notification. The Public Service Commission, supported by the state, countered that para 13 of the original notification expressly empowered it to cancel or modify the notification at any stage, and the cancellation was necessitated both to accommodate the enhanced reservation for ST candidates and to adopt the revised 1:50 ratio introduced under GO's MS number 29. It was further submitted that nearly 31,000 candidates had downloaded hall tickets for the main schedule on 21/10/2024, and stalling the process would prejudice the legitimate expectations of thousands. The Commission also highlighted that objections to the preliminary key had been duly referred to an expert body whose views were binding on the Commission. Justice Shavili, writing for the bench, noted that the appellants have participated in the process, would not approbate and reprobate by later challenging the notification. The court reiterated that candidates who submit themselves to a selection process cannot turn round and question it upon failure. The bench held that the court lacks the expertise to second guess the correctness of answers finalized by an expert body, and that judicial intervention in such academic matters is limited. The plea of postponement of the mains was rejected, noting that repeated stalling of Group 1 recruitment since 2022 had already caused irreparable hardships to thousands of aspirants. In conclusion, the division bench dismissed the writ appeals, affirming the learned single judge Justice Pulla Karthik's judgment. The judgment reaffirmed two principles that mark Justice Shavili's service law jurisprudence. First, that fairness to candidates must be balanced with the need for administrative certainty in large-scale recruitments, and second, that courts must exercise restraint in academic evaluation while ensuring procedural transparency. In the case of P. Ranjan Kumar versus State of Telangana and another, reported in 2021 SEC Online TS 1428, by a division bench of Justice Abhinand Kumar Shavili and Justice K. Lakshman, the judgment was authored by Justice Shavili. The writ petitioner, a judicial officer appointed in 1994 and later promoted as senior civil judge and district and sessions judge, assailed GOMS number 61, imposing the major penalty of compulsory retirement. The disciplinary action followed complaints made while he was serving as additional district judge Jagitial. He was placed under suspension, served with a charge memo. After a regular inquiry, the inquiry officer held parts of charge number 1 not proved, but found the second part of the first limb of charge number 1 and charges 3 and 4 proved. The disciplinary authority recommended compulsory retirement and the government issued this impugned GO. The petitioner urged that the complainant lacked a sworn affidavit and that standing orders 147 and 148 governing vigilance were not followed, that the registrar vigilance rather than the Honourable Chief Justice had initiated the process, that the inquiry officer wrongly split the first limb of charge 1 and order 20 CPC was inapplicable for motor vehicle accident claims, that directing deposit in ICICI was a trivial irregularity adopted from predecessors and that compulsory retirement was shockingly disproportionate. The respondents in turn submitted that sworn affidavits were in fact obtained and statements recorded in the petitioner's presence, that a discreet inquiry preceded initiation, that the petitioner showed no prejudice from any alleged procedural lapse. Lordships held that even one proved charge can sustain a major penalty, that in the event charges 3 and 4 were independently proved and the second part of the first charge limb of charge 1 overlapped with 3, supported by documentary evidence of delayed pronouncements. On standing orders 147-148, the bench noted the discreet inquiry undertaken and found no no demonstrable prejudice to vitiate the process. Given the nature of misconduct found and the fact that the authority had already taken a lenient view by awarding compulsory retirement, permitting pensionary benefits, no interference was warranted. The writ petition was dismissed. This decision reflects Justice Shavili's steady approach to disciplinary jurisprudence, careful separation of substantive and procedural infirmities, insisting on the prejudice test before judicial interference, recognition that one proved charge may suffice for penalty, that adherence to institutional circulars on financial safeguards is a must. In the case of Sanskruti Township versus State of Telangana and others, Division Bench of Justice Satish Chandra Sharma and Justice Abhinand Kumar Shavili, wherein the judgment was authored by His Lordship Justice Abhinand Kumar Shavili for the Division Bench, is in respect of a township represented by its secretary, questioned the notice of 1421 under section 185 of the Telangana Municipalities Act, treating the compound wall and gates erected around the township as encroachments and directing their removal within 3 days to provide access to internal roads. The appellant contended that the township had been originally developed and demarcated as a gated community by the developer, who had constructed the compound wall and gates to regulate ingress and egress. It was urged that the impugn notice was issued at the behest of neighboring layouts, and the township had always been treated as a closed gated layout. On the other hand, the respondents argued that the developer's request to declare the township as a gated community had been rejected by the competent authority by the proceedings of 24/2011, which had attained finality. No challenge was ever made to those proceedings. Further, it was submitted that Rule 23D of the Telangana Gram Panchayat and Development Layout Building Rules 2022, the local body retained the right to declare any road as public for connectivity purposes. Moreover, all the roads and public utility service within the township had been handed over to the Gram Panchayat on 18/12/2010, which later became part of the municipality. Consequently, the township has no legal basis to claim exclusive gated status. His Lordships also considered the judgment in Koganti Venkata Suryanarayana versus State of Andhra Pradesh, wherein it was held that roads and open spaces in sanctioned layouts, once gifted to the local authorities, vest in it and cannot be fenced off by private parties. Applying this principle, the court reiterated that in the absence of any order declaring the appellant township as a gated community, it would not prevent ingress and egress of neighboring layouts. In conclusion, the division bench dismissed the writ appeal, affirming the view of the learned single judge, and held that the impugn notice was validly issued. The ruling reinforced the principle that private claims of exclusivity cannot override public rights in respect of roads and spaces vested in local bodies, particularly where statutory rules like 24D and prior orders rejected the gated community status. The judgment illustrates His Lordship's pragmatic approach in urban governance and municipal law, emphasizing the supremacy of statutory vesting of public spaces in local authorities, the importance of administrative finality, and the need to balance individual residential conveniences with community connectivity and larger public interest. The case of State of Telangana versus Krishna Chetana, 2024 SCC Online, decided on 5th February 24 by a division bench of Justice Abhinand Kumar Shavili and Justice Namavaram Raishar Rao. The appeal arose from the order of a learned single judge dated 27 December 23, which had restrained the state from applying the process of normalization in the recruitment of women candidates to the posts of stipendiary cadet trainees and stipendiary credit trainee reserve sub-inspector of police. The writ petitioners contended that since the physical efficiency test for women comprised only a single event, an 800 meters run, normalization was arbitrary and unjustified. On behalf of the appellant state, it was urged that the notification dated 24th April 2022 itself prescribed a detailed normalization formula for post code 12. It was further argued that the principle of normalization was intended to balance the recruitment process across gender categories and not confined to multiplicity of events. Reliance was placed on the earlier judgment in WP number 15675, which upheld the very procedure, as well as Writ Appeal 809 of 2019, where a division bench had affirmed the application of normalization in police recruitment. The writ petitioners, on the other hand, contended that applying the normalization formula disadvantaged female candidates as their raw marks were being reduced without justification. They sought to distinguish the earlier judgments on the ground that in those cases the physical efficiency test involved multiple events, whereas in the present recruitment it was confined to a single event, thereby making normalization unnecessary and discriminatory. The bench held that the writ petitioners had neither challenged the notification dated 25th April 2022 nor demonstrated any concrete prejudice caused by application of the normalization formula. The court noted that the formula was clearly spelled out in the notification and applied to ensure fairness between male and female candidates, and that the principle had already been judicially upheld in similar cases, binding on the single judge. His Lordships observed that the learned single judge's contrary view was unsustainable, as it disregarded binding precedent and failed to establish how the petitioners were adversely affected. Accordingly, the division bench set aside the order of the learned single judge, allowed the writ appeal, affirming the validity of applying the normalization formula. The judgment highlights His Lordship's emphasis on consistency in recruitment jurisprudence, reinforcing that challenges to statutory recruitment processes must establish demonstrable prejudice and that binding precedent must guide judicial determinations. It exemplifies His Lordship's fidelity to legal certainty while ensuring fairness in large-scale public service recruitment. The case of Telangana Tribal Welfare Residential Educational Institutions versus Chilukuri Praveena, reported in 2024 SSC Online by a division bench of Justice Abhinand Kumar Shavili and Justice Namaru Rao. The writ appeal was preferred against the order dated 10th April 2023, where a learned single judge had interfered with the recruitment process of the posts of physical education teachers under notification of 2017, issued by the Telangana State Public Service Commission. The dispute centered on eligibility between diploma holders and graduate candidates for appointment to the physical education teachers posts in different classes. The appellants contended that in line with the National Council for Teacher Education notification dated 12/11/2014, the Telangana State Public Service Commission had issued a composite notification covering 616 posts across classes 5 to 8 and classes 9 and 10, describing diploma as a minimum qualification but also making graduates eligible. Earlier diploma holders had succeeded before a single judge, where it was directed that for classes 1 to 8 only diploma holders were eligible. Appeals filed by the state and graduate candidates in Writ Appeal 210 of 2020 and connected matters culminated in an order wherein the state undertook to segregate PET posts between classes 5 to 8 and classes 9 to 10 and to apply eligibility strictly in terms of the NCTE regulations. Subsequently, the state issued a memo dated 8/12/2021 restricting eligibility for classes 5 to 8 only to diploma holders, which the single judge upheld, directing Public Service Commission to issue a fresh notification. These promoted the present writ appeal by the society and graduate teachers, arguing that class-wise segregation of PET posts was impractical as recruitment was carried out institution-wise, not class-wise. On the other hand, Council for Diploma Holders relied on the judgment of the Honourable Supreme Court in Devesh Sharma versus Union of India, where it was categorically held that for primary teaching posts up to class 5, diploma was the mandatory qualification. The Honourable Bench observed that the learned single judge's order had travelled beyond the scope of review and clarification, and that the earlier division bench had already provided the governing framework. The court clarified that where recruitment was conducted exclusively for class 5, only diploma holders would be considered. For class 6 to 8, both diploma holders and graduate candidates were eligible, and for class 9 and 10, only graduates were eligible. Recognizing that recruitment in the appellant institutions was institution-wise rather than class-specific, the court tailored the directions to align with practical realities while ensuring conformity with statutory norms. Accordingly, the writ appeal was disposed of with the above clarification, setting aside the contrary directions of the learned single judge. This decision reflects His Lordship's pragmatic approach in reconciling statutory regulations with the functional needs of educational institutions. It demonstrates His Lordship's fidelity to binding precedent, sensitivity to practical feasibility, and ability to craft clear directions balancing the rights of competing stakeholders. Lordship's judicial temperament was marked by courtesy, forthrightness, and balance. To the juniors appearing from the bar, he was always encouraging. The bench under his stewardship never lost sight of the human dimension behind every case title. Outside the court, Justice Abhinand Kumar Shavili is a devoted family man, married to Srimati Sunita V. Abhinand, and is blessed with 2 children, daughter Kumari Akanksha Arya, Yashoda Shavili, who is in the final year of MBBS course at Narayana Medical College, Nellore, and his son Aditya Aryan Abhiyanshul Shavili, who is pursuing his intermediate studies at Hon'ble Reddy College, Hyderabad, with an intention to pursue study of law. His Lordship hails from a family of doctors with 4 elder brothers and 2 elder sisters, where most of them are in the medical profession. Yet by choosing the path of law, he carved for himself a distinct and distinguished identity within the family and otherwise. Beyond the bench, His Lordship has a fondness for music, a passion for cricket, and a love for long drives. Known for his humility and generosity, he is deeply admired for his willingness to help those in need, a quality that reflects both his personal warmth and his noble lineage. His Lordship's father, Dr. Subbarao Shavili, had a deep passion for vintage automobiles. During his years of service in the Marathwada region, he owned a classic Austin 1926 make and a Morris Minor 8 1936 make and a 2-wheeler, the James vehicle with a hand gear rod, symbols of his love for timeless craftsmanship and mechanical beauty. That love for vintage cars has endured as a hobby, cherished and continued by Justice Shavili and his family, who have lovingly restored and maintained these vehicles as a tribute to their father's memory and enduring values. On behalf of the entire legal fraternity, I place on record our deep appreciation and gratitude for the exemplary service rendered by Honourable Justice Abhinand Kumar Shavili. Lordship leaves behind a legacy of integrity, clarity, and compassion. The jurisprudence he has contributed, particularly in service law, will continue to guide the inspire future generations of judges and lawyers. On behalf of the entire legal fraternity, I convey our respectful thanks and best wishes on your Lordship's retirement and future endeavors.
My esteemed colleagues on the bench, Mr. B. Narasimha Sarma, Additional Solicitor General of India, Mr. A. Sudarshan Reddy, Learned Advocate General, Mr. A. Narasimha Reddy, Chairman Bar Council of Telangana, Mr. A. Jagan, President, Telangana High Court Advocates Association, learned senior advocates and members of the bar, learned registrars, member secretary, law secretary, secretary of Legal Services Authority, High Court Legal Services Committee, learned judicial officers and other officers of the High Court. We have assembled here to bid adieu to my learned brother, Honourable Mr. Justice Abhinand Kumar Shavili, who is demitting office today after 8 years on the bench of this court. Justice Shavili was enrolled as an advocate on 31st August 1989, and initially he joined the office of Sri D. Lingarao Advocate and later the office of former Justice Nuti Rama Mohan Rao. During his stint at the bar, Brother Justice Shavili successfully handled a diverse range of cases focusing on service law and constitutional law. He also held positions of responsibility including standing counsel for the High Court. Justice Shavili assumed office as a judge of the High Court of Judicature at Hyderabad for the state of Telangana and state of Andhra Pradesh on 21st September 2017. And since then he has played a stellar role in serving this institution with dedication and integrity. He was acting Chief Justice from 15 to 23rd July 2023 of this court. During his tenure as a judge, Justice Shavili has authored many reportable judgments covering diverse branches of law which are reflective of his keen intellect and deep understanding of law. Brother Shavili, during his stint as a judge, has disposed of more than 30,221 cases, which is a glowing tribute to his hard work and passion for dispensing justice. As enumerated exhaustively by the learned Advocate General, Justice Shavili's competence, caliber, and commitment to the principles of law are reflected in his judgment and orders. Justice Shavili has also effectively shouldered huge administrative responsibilities while acting as the chairperson of various committees and as an administrative judge of various districts. As the judge in charge and president of Judicial Academy, Brother Shavili was actively involved in the timely conducting of various programs, foundation courses, workshops, professional advancement courses for judges, disposal of POCSO and rape cases to public prosecutors, etc. He also permitted to modify the computer lab into e-digital classroom to accommodate 60 to 70 officers and also permitted for acoustic works for e-classroom. As chairman of the High Court Legal Services Committee, Brother Shavili also took active interest in ensuring that the eligible litigants get competent and timely legal aid to pursue their claims and defend their rights in a court of law. During his tenure, a total 272 number of panel lawyers were engaged by the High Court Legal Services Committee to provide legal assistance to the beneficiaries. That apart, 7 National Lok Adalats were conducted and 1196 pending cases and 245 pre-litigation cases were settled, awarding a compensation of Rs 78 crores. As we bid adieu to Brother Shavili, I wholeheartedly congratulate him on an illustrious career on the bench, which could not have been possible without the sacrifice of his better half, Srimati V. Sunita Abhinand, and his family members. I am sure he would get much more time to spend with his family, Madam Sunita Abhinand, daughter Kumari Akanksha Arya Yashoda Shavili, and son Chiranjeev Aditya Aryan Adhyanshul Shavili. However, I am also reminded of the famous saying that there is no such thing as a farewell for a judge. For a judge is not known by his robes, but by his fairness, integrity, and unwavering commitment to justice. I am more than confident that Brother Shavili would continue to contribute meaningfully to the society through his wide learning and experience. I, on my behalf and on behalf of my colleagues on the bench, wish him good health and success in his future innings.
Honourable Chief Justice Sri Abhinand Kumar Singh, my brother and sister judges, Advocate General Sri A. Sudarshan Reddy, Additional Solicitor General B. Narasimha Sharma, Deputy Solicitor General N. Bhujanga Rao, Bar Council Chairman A. Narasimha Reddy, Public Prosecutor Palle Nageshwar Rao, Bar Association President Sri A. Jagan, Senior Counsels, Junior Counsels, Registrars of High Court, ladies and gentlemen, a very good evening to everyone. I would like to start by thanking the Advocate General and Honourable Chief Justice for their kind words. I hail from a family of doctors. My father and my siblings have pursued medicine. I am the first generation advocate in my family. My parents were very simple, humble and honest. My father, a dedicated doctor, used to travel on his bicycle to visit his patients and treat them. He has inculcated these kind of habits, values of honesty, hard work and humility in all of us, in his children. Teachings of my parents have played a very important role in my life. Their teachings have shaped me for what I am today. Being the youngest in the family and for the first generation advocate was a very difficult journey to undertake. In fact, pursuing law as a career itself was a big twist in my career. I had given medical entrance examination but could not secure medical seat. I have decided to try my chance and prepare for MBA examination. And in the morning session, I have written MBA examination. Very casually, I have written the law examination. Even in these two courses, I could not secure admission in the first list. Only I have received some small slip from Osmania University during December saying that somebody has vacated a seat. Will you come and please join? That's how, by accident, I joined law course and completed the law course. And I got in, after completing my law, I got enrolled as an advocate on 31st August 1989. Initially, I was very hesitant and confused about this legal career. Initially, I joined the office of Sri Lingarao. Still, lot of confusion was prevailing in my mind. During this period, as uncertainty was there, my classmate and my good friend from Nizam College, Sri J. Sudhir, introduced me to Justice Nuti Rammohan Rao, as he was a practicing advocate in the month of February 1993. He has readily accepted me as his junior. Then I joined his office on 2nd February 1993, and thereafterwards, though it was a very tough journey, but there was no looking back. I was associated with Nuti Rammohan Rao, who later became judge of this court. I was associated for 14 long years. Then I became again independent by default because he has become judge. That's how I become independent. So from 2006 to 2016, again it was a really very hard work. And in these 10 years of my service, my services were recognized, and I convey my heartfelt thanks to Honourable Justice S.V. Bhatti, who was instrumental in appointing me as the standing counsel for the High Court, and also proposing my name to the Collegium along with Justice P. Naveen Rao, Justice Challa Kodanram, and during 2016. And I express my sincere gratitude to them and Collegium headed by former Chief Justice Dilip Bosale, who has recommended my name for elevation as a High Court, Judge of High Court. My life consisted of 3 innings, like a test match. 4th one is also there, I'll tell you. Comparison can be drawn between a test match. My professional life, each quarter representing an inning. First innings as a junior advocate, second innings as an independent lawyer, third innings appointment as a judge of High Court. And I intend to commence my 4th innings as a practicing advocate, hopefully. Let us see how things will go on. During my tenure as a judge of this court, I had adopted a system of listing cases, adjourning cases by 2 weeks to ensure that each case reaches and every case can be adjudicated. For this, I know many advocates should label my court as 2 weeks court. By adopting this 2 weeks adjournment policy, I ensured that every case reaches in my court. The question of not reaching any case in my court did not arise at all. That's a testimony to all advocates. I've been very fortunate to have unwavering support of my family members in every endeavor which I have undertaken, especially my wife, who had been a pillar of strength, patiently helping me to raise my 2 wonderful children. I'm also grateful to my nephews, Avinash, Akshay, Akash, Arush, and 2 nieces, Sangeeta, who is also an advocate, who has completed law, yet to become an advocate, and another niece, she is pursuing medicine in West Indies. Her name is Akshita. Today, all my achievements are a result of my hard work and immense support provided by brothers and sisters. I owe much of my journey to them. Right from my childhood, I am a devotee of Lord Krishna and a firm believer of karma. What a person does today comes back to us. That is a result of karma, which I have been telling frequent in the open courts also. I had made a habit of writing my mother's name and the phrase Om Namo Bhagavate Vasudevaya before starting my court proceedings. This practice helped me to act with clarity, calmness in all situations. The judiciary must always remain a place of ethics, integrity, good policies with truth, fairness guides every decision. So this is a very important which I followed all through my career. I convey my gratitude to all my staff members, especially court officer Srimati Ratam Sethi Madhavi, who has worked meticulously and efficiently, personal secretary K. Venkat Raju, who has worked effectively in taking care of my judgments, my court masters Kamla Kumari, Dhanalakshmi, Pratyusha, second court officer Vishwarupa, system assistant Abhilash Reddy, research assistant P. Subbaraju, and Abdul Rab Malik, PSO my gunmen Abdul Karim and D. Narsimha Reddy, attenders Yadgiri and Tahir Ali, and KV Raman Rao, typist, who had rendered his assistance in filing my income tax returns. I am also thankful to all the police personnel who have guarded my house 24 hours and have been great help to my family and have served with us with utmost dedication. That is Ramchandra and Bhakta Vassalam, Balemia, Sheikh Shambhu, Venkanna, and Narayana Nayak. And also my sincere gratitude to all the persons who have assisted me during my tenure, driver Lingaya, cook Venkatesh, late cook Vasant Kumar, Dhobi, late Danaya, and gardeners. I would also like to thank the medical staff, Pandu and Johnson, who are also very helpful to all my medical leads, not only mine, also my family members. This support has been invaluable. Their support has been very invaluable, acting promptly whenever needed. We are also grateful for their service. I would like to thank the protocol staff, Pawan and his team, who have always ensured good services wherever I visited. And lastly, I would like to thank the electricians, carpenters, other staff of High Court. As a parting message, I would urge everyone to uphold the law with dignity. Let justice be the light that never dims. With this small message, I remain. Thank you very much for giving this wonderful opportunity.